That's not a defense. I used drugs and I got bad drugs, so therefore I'm hallucinating. But I see that there are issues where who knows, maybe the behavior wouldn't have been what it was, because what I'm reading is he admits to it, and it says he stated that he set it up, that everything had been set up when Flores got pregnant. When asked who Flores was, he stated she was God and he was God, and the baby in her named Jesus. And then he said, I lit it up and it went up.
Enjoy the video. Hit the like button.
State versus Zachary Albert Dyke. Could I have the parties announced for the record? State.
Megan Galloway for the state.
Lorraine Ephraim for Mr. Dyke.
Are you Mr. Dyke?
Zachary Albert Dyke.
All right.
Dyke.
Counsel, have you received all discovery? Do you understand? And count one, you're charged with arson with intent to damage a habitation or place of worship.
Yes, Your
And
Honor.
in count two, you're charged also with arson with intent to damage a habitat or place of worship.
Yes, Your Honor.
All right. Do you understand those are first degree felonies?
Yes, Your Honor.
And the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Well, I understand what you're saying with the disagreements with that.
Yes. And to that end, I actually made a notation in the paperwork because it generally says you believe your client was legally sane at the time, and we're not urging that defense, but I wouldn't be, want to be saying that I couldn't urge it under different circumstances. That makes sense.
All right. Well, I don't step behind jury's verdicts. They're saying he was sane.
It were competent at the time.
Well, they're saying he's competent at the time.
Competent now. Sanity would be a trial defense.
Yeah.
And we're not urging that trial defense.
All right.
Does that make sense?
Yes. But I see that there, in really reading this police report, where
Had to
he
do-
thought someone was God.
It had to do with medication, Your Honor.
Okay.
My medication got all messed up and I wasn't in my right state of mind at the time. And I know that 100%. Like at that time, I was not in my right state of mind. And whenever I came into the jail, I wasn't in my right state of mind either, because I've been in recovery for a long time and I was on maintenance meds, methadone, and I was detoxing off of those medications whenever I came in here. And I didn't have the right medications being in the thing, but I've been in here for 2 years now and I'm really level headed now. But when I first came in here, I was not right.
There was an initial, well, let me put it this way. There was an initial finding of an agreed incompetence to stand trial.
Mhm.
Let me restate this. So the jury trial was on the issue of whether he had been restored to competency. And I contested that, much to my client's disagreement.
Mhm.
And the jury did find that he had been restored and that he was now competent. And so that's what put us back on your trial docket today. So it was pending quite a while he was in restoration posture.
All right. So here's my question, and I don't want to go behind anybody's agreements that they've worked out. I normally don't do it, but I'm reading the police report.
I know.
And I know that sometimes that people are using drugs, and that's not a defense. I use drugs and I got bad drugs, so therefore I'm hallucinating. But I see that there are issues where who knows, maybe the behavior wouldn't have been what it was, because what I'm reading is he admits to it, and it says he stated that he set it up, that everything had been set up when Flores got pregnant. When asked who Flores was, he stated she was God and he was God, and the baby in her named Jesus. And then he said, I lit it up and it went up. And he's like, I think it was the table.
And Your Honor,
And this has
sorry.
been an ongoing setup, and they've been telling me fire and water. When asked what he used to light the fire, he said a lighter. When asked what he was thinking after he lit the fire, that was the old me. It's gone. Then it was a new me. That's what they're telling me, that the old me and I have to leave it all behind. So what was set on fire was a table, a chair, and a bed. So what is his criminal history?
Your Honor. Can I say one
Do
thing
you
real quick?
do you feel as though you're losing this argument?
No. I just
Then why
want to
you're
say,
adding?
I just want
Then
to say
you,
that
you may
there's,
not want to add. I'm trying to figure out certain things here. Yes.
I'm trying to help you.
Stop.
Yeah.
She didn't ask you.
But going to what the court has.
And mind you, I'm all for following agreements. I'm just trying to get to the bottom of, my determination is whether agreements are appropriate or not.
But I have taken into consideration the court's concerns as well, and that's something that we have conferred about alternatives, and we just wound up
Okay.
where we are. So regarding his criminal history, he does have, so like a misdemeanor estate, from 2007, UCW from 2017, a PG3 possession less than 28 grams from 2020, a resisting arrest, from 2020, a possession PG1 less than a gram from 2017. The offense that we're here for today, a possession PG1 1 to 4 from 2017, a 4 to 200 possession PG1 from 2018, a possession of marijuana 5 to 50 pounds from 2020, and then PG3/4 above 28 grams from 2017. I'm sorry, that was out of order.
No.
And I think most of those did not result in convictions. Many were dismissed or otherwise resolved. So I think what would actually, I mean, I know you're just reading about arrests or bookings, but I think in terms of like what is actually in terms of conviction or,
Nothing.
So
I don't think he has any.
that would be correct. So he was only placed on deferred adjudication for a misdemeanor resisting.
All right.
He has almost 2 years credit pending incompetency restoration. So he's been in custody quite a while, which was another factor in our discussions today. As far as I can ascertain, I don't see that this becomes a 3G in any way. I
Okay.
can't represent when he would get paroled, but just that he would have what it appears to be normal parole eligibility.
All right. And in the,
In his I mean, there was a lot of contact during the pendency of the competency proceedings with the DA's office and the family, and we had a pretty intense trial on the issue.
all right. So what is this with regards to the complainant listed is Dike as well? Who is that?
Mom,
His mom.
uh-huh.
And is she aware of this?
Judge, so I didn't reach out to her today. During the competency,
She testified.
did reach out and I have correspondence from her where she's requesting treatment for the defendant. But like I said, that was explored in our negotiations.
She did testify. I think I think as you can imagine, many parents would be, highly conflicted here. This was serious. She bought this for him, whether it was hers or his by gift, might be a dispute, but nevertheless, it was her funds that paid for it and it's gone, destroyed to the ground. She's obviously loves her son, very concerned about him. And so I think she would be, she doesn't expect restitution. I think it was covered by insurance. I'm not sure.
There was no insurance claim on it, but it was
All right,
actually.
as I can say, this is what I'm saying. And I will follow your agreement. There's some times where I may think, this is very harsh. There may be some times where I think this is not harsh enough. And I'm just trying to discover, is this a prison case? Is it not a prison case? That's what I'm trying to get to the bottom to. Sometimes when people commit offenses, does it appear that you're losing this argument?
No, I just want to say
Okay.
a few things because you're saying that.
No, can you just wait because she's
Okay.
the judge and she's speaking.
I understand.
All
If
right,
you don't
so-
mind.
So sometimes there are reasons maybe why people do things. And then sometimes you have somebody, they're just a bad apple. This is just what they're going to do. As the attorney was in here saying that raccoons and other animals just come in and destroy chicken, well, coyotes, I think he said, destroy chicken for no reason, not hungry, just like, why not? So I'm struggling a little bit with this one because based upon what I'm reading, there's mental health issues. Maybe those mental health issues were drug induced. If that is, you got to stop using drugs. So if you all want, I will follow this agreement. State, I know you are asking me to follow this agreement. Do you all want to discuss some more or?
I can discuss with Efron some more, but I do want the court to know.
Yes.
Your impressions are not lost on me. There are things that I did. consider.
Okay.
Not saying that I'm going against you, but.
No.
What we've talked about as well, but we can talk something.
Oh, and let me just tell you, go against me. I'm fine with that because I want to hear everything, the good, the bad, the ugly, because I'm trying to
I can go to
make a decision that I think is appropriate. So if you feel like this is appropriate and you both feel like this is appropriate, then I'll go along with it. I just have certain questions. So if y'all want to, what I can do, we're getting close to 5 and the deputies need to take him back. So if y'all want, I can have this recalled tomorrow and the plea will still be here.
That's fine.
Right, we can't request them to already pass the.
Okay. Well, we can have him by Zoom, right?
Or by tomorrow, late morning or afternoon? I mean, I may be here. a
All right.
while.
Yeah, let's see.
Okay,
Let's say tomorrow, maybe by Zoom, if
Okay.
he can't be requested. I think it's better to do that than to
I,
rush judgment.
yes, well. what's this?
All right, we'll recall tomorrow. And Miss Efron, if you want his mother maybe by Zoom to give everybody some more insights into this, that would be great. All right, thank you. We'll see
Okay.
y'all tomorrow. State of Texas versus Zachary Dykey. Can I have parties announced for the record?
Lorraine Efren for Mr. Dykey.
And are you Mr. Dykey?
Yes, Your Honor.
All right, so we had reset this because the court had some concerns about the offer and whether or not this offer was in the interest of justice or at the best offer to protect the community and also get Mr. Dykey the help that he needs. Defense, did you have a ample opportunity to discuss these issues with your client?
Yes, Your Honor.
And are you asking to proceed with the plea bargain agreement as presented?
Yes, Your Honor.
And Mr. Dykey, are you asking the court to follow the plea bargain agreement as presented?
Yes, Your Honor.
All right, then the court will, as previously stated, the court will find you guilty of count 1 and count 2. Count 1 and 2 is to run concurrently. The court will sentence you to 8 years in the prison and count 1 and count 2. You get credit for any time served. There's a $2,000 fine, time and money to run concurrent. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
And counsel also adds a therapeutic community.
Oh, thank you.
You're welcome.
Thank you.
All right, good luck to you. Make better choices.
And